Have the appearances firstly for the petitioners in petition 88 of 2020.
Good afternoon, Your Honor.
Yes, go ahead.
I appear together with Mr. John Germain, Senior Counsel, and Mr. Roy Zilford, Senior Counsel, and Mr. Raphael Trotman, for the petitioners in this matter.
Could you give me your name, please?
Sorry, please, Your Honor. Arlene Joseph.
Could I have the names of counsel for the petitioners in petition 99 of 2020?
If it pleases you, this court, madam, I, Darren Wade, appeared with Mr. Mayor Robertson, Mr. Kemraj Ramchatan, Mr. Gary Best, Ms. Gita Chadman Edmund, and madam, I'm also instructed that Mr. Nigel Hughes is now part of the team, or however, I'm not sure whether or not those documents have been filed.
Sorry, Mr. Wade. I have yourself, I have Mr. Mayor Robertson, Mr. Ramjatan, and I missed you on the others except for Mr. Hughes at the end, am I right?
Yes, please, madam. Did Mr. Gary Best and Ms. Gita Chandan Edmund.
Mr. Gary
and
Best.
We led, pardon me?
Mr. Wade, please slow down. Mr. Gary Best.
Ms. Gita Chandan Edmund. And we are led by Mr. Rex McKay, Senior Counsel.
Yes, I will now have the behalf of the respondents in order, first to 12. Is anyone in the hearing for the first respondent, Chief Elections Officer? The second respondent.
Please, Your Honor.
Appearance.
Pastor Williams appears for the second name respondent, David Granger, for a partnership for national unity and alliance to change.
Third respondent. Third respondent.
Turn off. May it please, Your Honor. The Guyana Elections Commission, represented herein by the Chief Elections Officer, has not yet retained counsel, but will defend these proceedings. We're respectfully asking that our appearance be entered, and at the subsequent time, counsel will enter an appearance for and on behalf of the Chief Election Officer.
So, could I have your name, please, for the record?
Pardon me, Your Honor.
Could I have your name, please, for the record?
Sis Gunraj.
And you're saying, Mr. Gunraj, that you are professionally appearing on behalf of the CEO?
No, please, Your Honor. As a courtesy to the court and as a member of the Guyana Elections Commission, I'm informing the court that the commission has taken a decision that it will defend the proceedings and that at some time subsequent hereto, hopefully very soon, counsel will enter an appearance on behalf of the Chief Elections Officer, the statutory officer of the commission named in these proceedings.
Very much.
Very much pleasure.
Yes, we go to the third respondent. Yes, the third respondent. I'm seeing Mr. Edmondson on the call, and I see Horatio Edmondson, representative of Federal United Party, is listed as the third respondent. Is anyone appearing for the third respondent?
Madam, good afternoon. Mr. Edmondson here. Mr. Crawford is online appearing for me, but maybe he has some difficulties. He just communicated to my office that he's online and trying to enter his appearance.
Very well, I've noted.
Thank you.
Fourth respondent.
May it please the court, Devendra Kissoon, in association with Sanjeev Datadin, Clay Hackett, Rishi Das, Therese Haddad, all led by Douglas Mendez, appearing amicus for the fourth named defendant, Dr. Bharat Jagdeo, as representative of the People's Progressive Party, Civic.
When you say amicus, what do you mean, Mr. Kissoon?
Your Honor, we are preserving our right to contest the jurisdiction of the court as to matters relating to service. So we're not formally entering an appearance, similarly, solely for the limited purpose of dealing with matters relating to service.
Yes, fifth respondent.
May it please Your Honor, Hari Ramkaran, appearing for John Flores, the fifth named respondent.
If it please Your Honor, Timothy Jonas, appearing for Asha Kissoon of the New Movement, the sixth respondent.
Seventh respondent.
May it please Your Honor, together with Mr. Donovan Rangaya, I respectfully. Hello?
Yes, please repeat.
Yes, please, madam. Together with Mr. Donovan Rangaya, I respectfully enter an appearance for the seventh named respondent.
Can I have your name, please?
Ganesh Hira, please, Your Honor.
Eighth respondent. Is anyone present for the eighth respondent? Din Kindi Ali, representing the Change Guyana. Ninth respondent, Patrick Bourne, People's Republican Party. Tenth respondent.
May it please you, Madam, Kamal Ramkaran, representing Jonathan Yearwood, representative of the list for a new and united Guyana.
11th respondent.
May it please the court, Kashir Khan with Mohammed Khan, Ivan Alert, Kalesh Lokman, and Joshua Abdul for Shazam Ali representing the Citizenship Initiative, the 11th respondent.
12th respondent. Respondent, Gerald Pereira, representative of the Organization for the Victory of the People. Is anyone appearing for Mr. Pereira? Very well, so I have all the appearances. And for those who have not attended, I should mention that very belated addresses for service were filed. Well, we received in petition 88 of 2020, we received 3 filings of address for service within time from the 5th, 6th, and 10th respondents. Though I should mention that the 10th respondent, his rubric is incorrect on his affidavit of service or his acknowledgement of service. So, Mr. Ramkaran, yes, you'll be permitted to amend your rubric. You left out 1 respondent, so you are 1 respondent short.
I'm very grateful, madam. I will do so in the course of tomorrow.
And then we received addresses for service or entries of appearance for the 2nd and 3rd respondent yesterday and today, respectively. In relation to petition number 99 of 2020, we only received an address for service from the 10th respondent, and between the 19th and today, the 22nd, we received addresses for service for the 11th respondent, 2nd respondent, and 3rd respondent. I should mention, so it is very clear, that respondents who do not file their addresses for service are and will be deemed served by notices left in the registry, so that any respondents who have not filed their addresses for service would not have been sent the link for this CMC, but of course you could have gotten your notices from the registry, or, well, which would have contained the link for this CMC.
May it please, Your Honor.
This applies pursuant to Rule 10 of the rules. Yes, Mr. Jones.
Your Honor has observed that the 6th named has filed an entry of appearance in respect of 88. The reason that no entry of appearance was filed is that we do not have a record of having been served the petition in 99. And therefore, my first information of 99 being heard for case management was when I received the electronic notification from your registrar. I wonder if the issue of actual service could be addressed. I have no objection to receiving service of 99 at this stage, but I don't have a record of having been served.
My understanding is that in relation to 99, I think this respondent was served by registered post pursuant to an order of court.
Ask if there is only 1 respondent named in 99, please, Your Honor.
Sorry, Mr. Jonas, I didn't hear you clearly.
May I inquire if only 1 respondent is named in 99, please, Your Honor?
When you say only 1 respondent was named in 99?
Well, Your Honor said that there's a record of an order of court mandating service by registered post. But does that mean on each of the several respondents? Are many respondents named in 99?
Yes.
Thank you very much, Your Honor. In that case, may I enter a provisional appearance, amicus, in 99?
Or just a minute, Mr. Jonas. Just might I inquire if the appearances, I will go through it again, because Mr. Jonas has, by his intervention, has brought something to my attention. Are the appearances the same in 99 for the respondents? So the first respondent, Mr. Gunraj.
Yes. Yes, please, Your Honor.
Second respondent, Mr. Williams.
Yes, please, Your Honor.
Third respondent, Mr. Edmondson in person.
Your
Yes,
Honor,
please, Mr. Go ahead.
Your Honor,
Fourth
Ryan Crawford for the third name respondent, Your Honor, along with Mr. Marcelin Bacchus. And I apologize for the earlier disconnection, madam.
Very well. So, Mr. Crawford, you are appearing for the third respondent in both petitions.
Yes, madam. The first 88, along with Mr. Chandra Sohan.
Okay, let me understand you. In 88, it is yourself and Mr. Sohan.
Yes, madam. And in 99, myself and Mr. Bacchus.
I understand you. Very well.
Thank you.
Yes, the fourth respondent, would it be Mr. Devendra Kissoon and the other named counsel?
That's
Bella
correct.
Mendez.
That's correct, Your Honor, for both.
Fifth respondent, Mr. Ramkaran, senior counsel. Mr. Ramkaran.
My apologies, Your Honor. Yes, please, Your Honor.
Sixth respondent, Mr. Jonas.
Yes, please, Your Honor.
Seventh respondent, Mr. Hira and Mr. Rangel.
Please, Your Honor.
The eighth respondent, Mr. Ali, representing the Change Guyana. Is anyone representing Mr. Ali on the call as yet? Very well. No appearance. Ninth respondent, Mr. Bourne, representing People's Republican Party. Okay, I report no appearance. 10th respondent, Mr. Kamal Ramkaran.
Yes, please, Your Honor. I would have filed an entry of appearance in both matters, Your Honor. Does Your Honor's file have both entries?
Confirming the appearances today. 11th respondent, Mr. Khan.
Yes, Your Honor. I am appearing.
Yes, please, Your Honor. The same attorneys appear for both, and I wanted to add also that we have filed entry of appearance in both matters. I noted that Your Honor mentioned an entry of appearance only in 99. Entries of appearance have been filed in both matters.
Well, and the 12th respondent, Gerald Pereira, Organization for the Victory of the People. Is anyone representing Mr. Pereira? Very well, recording no appearance.
May it please Your Honor.
Yes, I'm hearing you. Yes, Mr. Nandalan.
The Attorney General was served with both petitions in compliance with the National Assembly Validity of Elections Act. And I'm respectfully inquiring whether the court will hear an oral application for the Attorney General to join both petitions.
Well, my understanding of the rules, Mr. Nandalam, is that the Attorney General, as you pointed out, is a statutory officer who has to be served. And pursuant to Article 163 of the Constitution, the Attorney General is entitled to intervene. So permission is granted.
Thank you very much, Your Honor.
You can appear in person or by representative.
Might I enter that appearance now, please, Your Honor?
Yes.
I will be appearing in person, and appearing with me would be Miss Pratima Kisoon, Mr. Chevy Devonish, and Miss Rihanna Clark. And that would be in relation to petition number 88 and 99.
Thank you, Mr. Nandalam.
Most obliged, Your Honor.
Very well. I will now request that counsel, in relation to both petitions, give a brief synopsis of the cases and relief sought and how the petitioners will prove their respective cases so that the relief sought can be granted. I do appreciate that there may be other applications, but let me hear in a nutshell from each counsel for the petitioners what their case is about. You'll have about 5 minutes each to so present. Counsel in 88 of 2020.
May it please, Your Honor. Rochdale Ford, Your Honor. Could I proceed?
Yes, you may proceed.
Thank you, Your Honor. Your Honor, this petition number 88 of 2020 seeks to raise for the court's consideration as part of the election petition filed under the National Assembly Validity of Election Act, the issues as to with respect to the validity of Order 60 of 2020, under which the recount was held and the results of the declarations were made. Your Honor, this petition also seeks to raise the issues as to the validity of Section 22 of the Election Laws Amendment Act, because it was under that provision that Order 60 of 2020 was brought into effect. Your Honor, we seek to raise in this issue, in this petition also, Your Honor, the legitimacy of the election report under Section 96, which we contend is required by the Representation of the People's Act to be based on the information furnished by the 10 returning officers. And in fact, in this case, it was generated on documents not referred to in the Representation of the People's Act, purportedly created under Order 60 of 2020, and for which none of those documents upon which the declarations were made, we contend are legal documents which ought to have been used. The election report, Your Honor, was based on certificates of district tabulation, a document which was never gazetted nor referred to in the laws of Guyana. Your Honor, we believe that the consequential declarations made by the Elections Commission and the Chairman of the Elections Commission declaring that Mohammed Irfan Ali was duly elected as the President of the Cooperative Republic of Guyana would consequently be unconstitutional and without any statutory basis to support such a declaration. Your Honor, we have filed an affidavit in support of the petition in which we referred to the relevant documents, attaching them as exhibits to those to the affidavit, Your Honor. Your Honor, in respect of this petition, we respectfully believe that it is premised on the determination of the legal issues, which I've tried to capture, Your Honor, very briefly, of course. I believe that it is an issue that will require legal arguments to be presented to the Honorable Court. Subject to Your Honor's guidance, I am of the view, and my team, we are of the view that there's no need necessarily for the leading of evidence in respect to the issues that we ask for the court to determine in this petition, Your Honor. Your Honor, I've tried to be very summary as far as practicable, without necessarily going through all the declarations and every relief asked for.
Thank you, Mr. Ford, because I would have asked you whether you were, how many witnesses you were going to call, but you have just indicated that you were of the view that there's no need to lead evidence and you will be relying on the affidavits and the exhibits on file.
Yes, please, Your Honor.
Thank you. I do have a question for you based on the relief sought, but let me hear counsel for the petition in relation to petition 99 of 2020.
Good afternoon, Your Honor. This is Mayor Robertson. Your Honor, petition 99 of 2020 is based on allegations of several irregularities in the conduct of the elections. Your Honor, I would not propose to go through each of them in detail, but they include widespread voter impersonation, widespread non-compliance with documentation as is required, a flawed voters list to begin with, and several other irregularities, Your Honor. We are asking for a declaration that the elections were not held in accordance with the... Sorry, Your Honor.
Yes, go ahead, Mr. Robertson. I'm hearing you.
I saw an interruption pop up on the screen. Your Honor, we're seeking a declaration that the GCOM did not meet its constitutional requirement of holding fair and credible elections as required by the Constitution. And as such, we're going to ask that the results of the election be set aside after the court makes declarations that the irregularities were found to exist in the conduct of the elections and therefore vitiated the entire process. Your Honor, this petition is going to require substantial evidentiary support, and it is anticipated that several witnesses will be called. Along with the petition, detailed affidavits were already filed. Several people will be called along the way to support the allegations set out in the details of those affidavits. I am sorry at this point, Your Honor, I cannot give a precise number, but I can endeavor to do that certainly within the next week, besides number of witnesses who will be called to present evidence in support of petition number 99.
Well, I'm surprised at that, Mr. Robertson, because having filed the petition on the 15th of September, and it's very voluminous in its content, one would expect that you would know how many witnesses you will be calling.
Your Honor, we have a very good idea of the number of witnesses. What we're trying to do is to fine tune it to decide which witnesses would do what. And I did not want to put a number out there and be bound by that number while we work on fine tuning the evidence that will be presented by each witness.
Well, I would have expected you would have been ready for this CMC because that will require, anyway, across that bridge. All right, I have two comments to make, but I think Mr. Kisoon, you wanted to raise a point. Let me hear the point. It may be that you will have to file a formal application, and I do have some notes and directions in relation to that. But let me hear from you what it is that you are raising.
Good afternoon, lady. This is Douglas Mendez here.
So, Mr. Mendez, you will be responding in this regard?
If I may please name.
Very well.
We understand that an order for substituted service was made.
Not very clear, Mr. Mendez. You sound very muffled.
Is this better, my lady?
A little better, yes.
Okay. We understand that an order was made that the petition be served on Mr. Jack Dero by registered post. We have, our inquiries so far have indicated that they have not yet been delivered by registered post. We have been attempting as best as possible to obtain copies of the documents that was filed in support of the application that was made. From the little bit that we understand so far, we haven't seen, for example, the orders that were made by the court. But we are concerned that the application that was made, certainly in relation to number 88, did not comply with the rules, and the order that was made in 99 did not comply with the rules. In other words, what the rules require is that you seek an order from the court, that the court is satisfied that the actions that were taken thus far were sufficient for service purposes, and therefore in effect service is deemed to have taken place. It does not appear that the orders reflect that, and certainly in the case of 88, it doesn't appear that that was the order that was sought. So this is a preliminary view, my lady, but we will firm it up as soon as we are able to see all of the documents that have been filed. But essentially, the application will be that that service has not been effected at all on Mr. Jack Dero, because the rule, the slip rule, if I may put it that way, that is there to deem the service was not followed in this case. But again, that is a provisional view, milady. We have not seen all of the documents, but we would seek the leave of the court to give a short period of time within which to ascertain exactly what the position is and to make an application if we think that the documents will support it.
But Mr. Mendez, I am not aware that the application, at least pursuant to the rules, that the application for what we can call substituted service is an inter partes application. The court would have received the application with the evidence, and the court would have ruled whether rightly or wrongly the order would have been made. And are you speaking to both petitions or only one?
Both petitions, lady. We are not suggesting that the application had to have been made inter partes. What we are saying is that the application had to be made in accordance with the rules. And the information that we have so far leads to the provisional view that the application was not made in accordance with the rules, and therefore that proper service has not been effected. And I repeat, my lady, that is the provisional view because we have not had proper sight of all of the documents, including in particular the formal order of the court.
Well, Mr. Mendez, as I said, I have a difficulty with your conceptualization of it because in my view, maybe you might have to make a formal application, but in my view, preliminarily, an application was made ex parte for substituted service in both petitions, and based on evidence that would have been tendered to the court would have reviewed the applications and made the order that there be substituted service. I'm aware that in 88 of 2020, the order for substituted service was via registered post, and I made an order in 99 of 2020 for substituted service by registered post. The order is made by the Honorable Justice Rishi Prasad. So from my perspective, the orders of court stand.
Certainly, my lady, the order clearly stands. But what we will be saying is that the application and the order were not in accordance with the rules. And in election petition matters, as we would know, the rules are required to be very strictly followed, certainly in relation to service. And the opportunity that is allowed to a petitioner who does not serve within time, and of course, as you know, my lady, if you don't serve within time, the petition is a nullity. The way you get out of it is providing, the way you get out of the requirement that you serve within a particular period of time is that you can make an application under the rules. And what we are saying provisionally, and I emphasize provisionally, my lady, is that the application and or the order did not comply with the rule, and therefore service has not been effected properly.
Well,
so we have to make the application, and I'm asking for a very short period of time to do so.
Sorry, I didn't hear you. Were muffled again.
Very sorry. I'm saying that we are asking for a very short period of time in order to finalize our position and to make a formal application.
You mentioned I don't need full arguments now. We will have to deal with this later. But you mentioned that non-service of the petition, well, from your perspective, flawed service would amount to non-service, which would mean that the petition is a nullity.
That's correct.
Whether it's a nullity in its entirety or as regards the party that you or the litigant that you represent.
Normally, it will be in its entirety. Because my client is a necessary party.
Brother, we'll have to have full arguments on this.
Certainly.
Now, apart from, just a minute. In relation to petition number 99 of 2020, Mr. Robertson, does appear that service on Mr. Granger, the second respondent, has been out of time. From our record, a petition was filed on September the 15th. It is my understanding from the rules that the petition must be served within 5 days, excluding the day of filing. According to the report of service, the petition was served on September the 25th, which would appear to be outside of the time for the service of the petition. According to my reckoning, the last date for service would have been September 22nd, given the intervening weekend. I've considered Section 8 and Rule 9 of the National Assembly Validity of Elections rules. You are not required to respond now, but if you care to, you can. But that is what I've seen on the record.
What I would say, Your Honor, that is contrary to the information I have, but as the court has so kindly allowed, I will respond formally at a later time.
Very well. Another issue that I would like to raise and it's in relation to both petitions. The prayers for relief in both petitions just a minute, please. In 88 of 2020, at paragraph Roman 13, one of the reliefs claim is an order that the chairman of the Guyana Elections Commission declare the presidential candidate designated on the APNU plus AFC list of candidates as the duly elected president of Guyana in accordance with Article 177 of the Constitution. In petition 99 of 2020, similar relief is sought I'll find it, but similar relief is sought that the presidential candidate designated on the APNU-AFC list of candidates be declared as the duly elected president of Guyana. My query is this. Section 4.2 of Chapter 104, that is the National Assembly Validity of Elections Act, provides that the respondent would be a person representing a list whose interest conflicts with the petition. The question is whether the second respondent has an interest that conflicts with the petition. The question does not have to be answered now. It is just a question that I have raised based on my reading and understanding of the rules, along with the prayer, well, that particular prayer for relief as stated in the petition. But then again, for the entire petition or both petitions, whether what is set out therein, whether the second respondent, whether his interest conflicts with the petitions. I raise this also in the context, we are not at that stage as yet, but as part of case management, as you know, the court can raise issues that are pertinent and relevant to be considered. When I read section 27(2) of the Act, it says a respondent who has given notice of intention not to oppose the petition shall not be allowed to appear or act as a party against the petition in any proceedings thereon. So one would expect, we have a couple of respondents who have not appeared. We will hear from them if they do appear. But I want to put respondents on notice that section 27(2) is a very important provision, so that if one is not opposing the petition, one has to so indicate to the court, and one would not be allowed to be a party. One would recognize that this is going to be a trial, at least in relation to 99 of 2020, a full-blown trial with witnesses. In those circumstances, respondents would be, of course, permitted to cross-examine the witnesses for the petitions, witnesses who were brought in support of the petitions. I have noted from the rules that quite unlike some other jurisdictions where I've read their authorities from those jurisdictions, which provide pretty specifically for the filing of answers, witness statements, and the calling of evidence by respondents to elections petitions. The Guyana Act and rules they're not so specific, but one would expect that in the context of a trial and provision in section 42 for the court to conduct the proceedings as it would generally in its civil jurisdiction, that witnesses will be called for and on behalf of the respondents, and cross-examination cross-examination would occur by both sides of the witnesses so brought, so that if it is that a party is not opposed or does not have an interest that is in conflict with the petition, then one would expect that particular respondent would not call witnesses. I hope I'm making myself clear. So if you can kindly read in preparation, section 27(2), and importantly, as I mentioned before, section 4(2) of the of chapter 104. Well, I've made these observations. I don't know whether counsel would like to say anything in relation to the observations, but I will give time for counsel to address on these issues, because I think to ask you to do so now may be a bit unfair, because the court is raising some matters which you may want to cogitate on as counsel for the parties.
Your Honor.
Yes, Mr. Nandala.
Since the Attorney General doesn't represent the public interest, might I be afforded an opportunity to offer some guidance in writing on the issues raised, in particular service and filing of the notice of the rules require a party who is not opposing, a respondent who is not opposing, to file a notice to that effect before the court, before the hearing of the petition.
Not before the hearing of the petition, Mr. Nandalam.
For the trial, sorry.
Trial. It has to be filed 6 days before the trial. I have not fixed the trial date. This is a case management conference.
Yes, I appreciate that, Your Honor.
But I'm just flagging it as an issue in the context of section 4.2 of the, just a minute. Yes, in the context of section 4.2 of the National Assembly Validity of Elections Act, Chapter 104. I'm just flagging it as an issue. Counsel must be given an opportunity to be heard, and of course, Attorney General, you will be heard also on this issue.
Thank you very much, Your Honor.
There were some other issues I was going to raise, but I think let me ask this question. Has anyone applied for made any requests for particulars? Any of the, separate and apart from the third respondent? Sorry, the fourth respondent. Has anyone made any requests for particulars pursuant to Rule 18? There are no applications before the court, but I'm just making sure, because all of that will shape and frame how I manage the case.
Your Honor, we've received no applications or requests, Your Honor.
Your Honor, with respect to petition 99, we have not received any requests from any of the respondents for particulars either.
Thank you. The other issue that I have noted on the rule in the provisions that pursuant to section 19, documents and papers may be inspected or produced on an order of court for the purposes of an election petition. It appears to me, well, the provision says that the party would have to apply with supporting evidence to satisfy the court that such inspection or production is required for the purposes of the election petition. In my view, and I must emphasize that this is a preliminary view based on my reading of the provisions, but it's subject to further submissions by counsel, I do not consider that another party can object to an application for the production of election documents or papers, or to inspect election documents and papers. Again, that is another issue that I'm raising for counsel to consider and address on if necessary, but that is my preliminary view of section 19 of chapter 104. So that parties may make an application with the required evidence for the production of election documents or papers, or for that matter, inspection of election documents and papers. So then this brings me to the issue of what next? All applications and submissions, well, let me deal with the applications first. All applications must be filed and or served, sorry, filed and served by November the 20th. Any applications must be filed and served on or before November the 20th. Where applications are made to the court, the applicant and any respondent responding thereto must not, and I emphasize, must not exhibit documents or exhibits that have already been filed with the court. We already have a voluminous amount of documents, and it has become the norm, at least here in Guyana, for litigants to exhibit documents that are already before the court with every application that is made. So if 20 documents have been exhibited before, they exhibit those 20 plus the 20 that they're relying on for the particular application. It makes no sense. So kindly do not exhibit documents that are already before the court. One can therefore make references to such documents or exhibits in your application. Any affidavits in answer to the applications, other than applications for election documents, must be filed and served, if necessary, on or before December the 4th. However, I emphasize that if there are legal arguments, being advanced, affidavits in answer must not be filed. In those instances, only submissions would be filed and served by the respondents on or before the said December the 4th. So if you have no evidence to contradict, please don't file an affidavit. Kindly just file your submissions. The petitioners would then file and serve submissions in reply if necessary on or before December the 18th. And any response by the respondents, if necessary, on or before January the 5th, 2021. All submissions are to be no more than 15 pages long, and even that is lengthy, inclusive of footnotes and references in Times New Roman font 12, 1.5 line spacing. All documentation from henceforth, apart from being filed, must also be emailed to the registrar, to the Chief Justice, on or before the stipulated dates. Mr. Mendez, I'm conscious that your application maybe should be dealt with a little differently. We might have to pull that forward, so it wouldn't fall into the same category as any other applications, whether it's for particulars, whether it's for election documents that have maybe filed by the parties. In the case of your application, your application is to be filed by the 5th of November. So it will have to be filed and served because it would affect the parties. So you'll have to serve it also.
Yes, please.
All responses will have to be by November the 19th. And Mr. Attorney General, the timelines would apply to you also.
Thank you very much, Your Honor.
Your Honor, to be clear, the application that is to be filed by November 5th, should that include submissions as well?
Sorry, I didn't hear you.
I'm asking whether the application should be accompanied by submissions on November the 5th.
That would shorten the process indeed, Mr. Mendez. So thank you for that suggestion. So it would be the application along with submissions. We file and serve by November the 5th, and responses by respondents. Well, those respondents who care to respond. If we don't receive a response from you, we know that you're not interested in this particular application. But respondents by respondents and the Attorney General to be served. I should say responses by way of affidavit and or submissions. Affidavit in answer. Be served and filed on or before November the 19th. And I will hear arguments on this on November the 24th. Well, some brief oral submissions encapsulating what you're advancing. Commencing at 9:30. And if necessary, November the 25th at 9:30. I can only work in the morning on the 24th and the 25th, as I already have other matters fixed. So November the 24th and November the 25th at 9:30 on each day in relation to the application made on behalf of the fourth respondent.
Your Honor, if I may, this is Devendra Kisoon. Would the court permit service of these applications by email on the parties' counsel as opposed to physical delivery to parties' counsel? And we could verify with a phone call to counsel that they've been received, given the number of counsel?
Yes, you can email. Service can be by email, but of course you would have your mechanisms for proof of service.
Most grateful, Your Honor.
But of course, you must still file the physical documents.
Yes, Your Honor.
I'm considering, in relation to the application on behalf of the fourth respondent, that really it is an engagement between that respondent and the petitioners, so that I only expect to get affidavits in answer and submissions from the petitioners and the Attorney General. The link will be sent out for the hearing. I'm not saying that the other respondents cannot attend, but I think it is so far, there's something else in the application that causes me to think otherwise. But that seems to be an engagement as between the fourth respondent and the respective petitioners. Mr. Mendez, do you have anything to say on that?
No, please, Your Honor.
Mr. Ford and Mr. Robertson.
No, Your Honor.
Very well. So,
No, Your Honor.
very well. So it will be limited. So it's not, apart from the Attorney General and the petitioners, the other respondents would not be permitted to respond to that specific application.
Your Honor, except that the Attorney General would like to offer some assistance in relation to observations that Your Honor made in relation to the service on respondent, second respondent. When I was granted leave, Your Honor, I thought that the leave extended to the Attorney General extending assistance in relation to service generally. And Your Honor made some observations in relation to the second respondent, which the Attorney General would like to offer some guidance, assistance on.
Very well.
Thank you very much, Your Honor.
Well, let me, maybe I've gotten ahead of myself. The issues raised by the court which speak to service on the second respondent, which speak to section 4(2) and section 27(2), though as I pointed out to the Attorney General, section 27(2) does not really apply at this stage, but I'm raising it as I'm red flagging it. I will give some shorter timelines for submissions in relation to those issues.
Most grateful, Your Honor.
Your Honor, may I make an inquiry if you are all through?
Yes, Mr. Mendes.
I'm just looking at the timelines, and you're requiring other applications to be made by November the 20th. By that time, of course, the application that we indicated provisionally we might make will have been made by November the 5th. They will be replied by November the 19th. And you have oral arguments by November the 24th. So of course, our application will not have been determined by then.
That's why I said, Mr. Mendes, I realize I'm getting ahead of myself.
So all I'm saying, Your Honor, is that we will also be making applications on November the 20th on the assumption that our application might not succeed. But that would be obviously without prejudice to the application.
Very well. So I think what I will have to do is address what are clearly now preliminary issues before we get to the other applications. As I thought about it, as I said, I've gotten ahead of myself in trying to move the process along. But one has to take a step.
Sorry, I'm not objecting to it, I'm just making clear that we will file applications on the November the 20th, but that would be without prejudice. I'm just making that clear front. I'm not suggesting that you.
I see, but my understanding, Mr. Mendes, is that you're saying, from your perspective, that's why I asked you what you meant when you said the petition is a nullity or the petitions are nullities. You are contending that the petitions are nullities because you are saying your client wasn't served.
Yes.
Or served according to the rules. If that is so, but you're still filing other applications, then in effect you're saying, well, you have a two-pronged attack, so to speak. it's a nullity, but if it's not a nullity, I'm filing other applications.
Well, that's what I'm saying. I didn't want to disrupt your timetabling, but at the same time, I wanted to make clear that we wouldn't want to lose the opportunity of making applications on November the 20th in the event that our application didn't succeed. But strictly speaking, Your Honor, our application should be heard first before anything else is done. But I didn't want to make that suggestion at all. I'm saying that the other applications can proceed, but as long as we make it clear that we are doing it without prejudice. In other words, I don't want anybody to take the point that we have somehow waived the application that we've made. That's all I'm saying. Not asking that at all that you disrupt your timetabling.
Very well. What I'm going to do now that I'm rethinking it is that we will hear the applications, or the application rather, filed on behalf of the fourth respondent as I have directed. As regards the issues of service, section 4.2 and section 22.7, section 27.2. I will hear submissions on these issues. So I will give timelines now for the submissions. Submissions by the petitioners. On or before November the on or before November the 10th. Submissions by respondents, and this would apply to all respondents and the AG, because it goes to the root, may go to the root of everything in relation to that particular, in relation to any particular respondent. Submissions by the other respondents and the Attorney General on or before November the 24th. And we will fix this for very well, and I will hear arguments on these issues on November the 30th. And December the 1st, vote at 9:30. In this regard, I will vacate the orders that I just made on the other submissions. Let us deal with these preliminary issues first, and then we will come to the other applications as necessary. Is everyone clear? I will issue the directions in writing. You will get the orders. Hopefully I can get them out by tomorrow, and they will be emailed to you. For those who have not appeared this afternoon, the orders will be in the registry. So the timelines I have given, but we will have oral arguments November 24 and 25 at 9:30 on the application on behalf of the fourth respondent. And in relation to issues of service generally, section 4.2 and section 27.2. I will hear arguments on November 24th and 30th. Sorry, November 24th. Sorry, November 26th and 30th. Is there anything anyone would like to raise before we wrap up?
Your Honor, just if I may, I'm terribly sorry. As I've been indicating, we have a provisional view, and I'm just a bit concerned that if it turns out that we decide not to make the application.
Sorry, you're so very muffled.
So this is why I was going to suggest that maybe you bring forward the date for the making of our application from November the 5th, so that we can shorten that period of time, just in case, as I say, we decide not to proceed, then we can inform you that we are not proceeding, and then you can deal with other matters.
Unfortunately, Mr. Mendez, I'm not hearing you clearly at all.
Oh, dear, I'm terribly sorry. It is better now?
If you can communicate with counsel who is in Guyana.
Your Honor, if I may assist, this is Devendra Kisoon. Senior is saying that the view that's being shared is a provisional one, and it may very well be that upon examination of the papers, an application will not be made. And he's expressed concern that if that's the case, the timelines may, in effect, work against what the court is trying to achieve. And he's respectfully suggesting that perhaps the date for him or for us to make that application be brought forward so that we can quickly apprise the court whether or not we intend to make an application. And in the event that we don't, then the court can then proceed to make the other provisional orders it intended to make in the first place.
Well, it could be brought forward by a week. To next week, Thursday, the 29th.
Much obliged, Your Honor. That will work for the fourth name respondent. In the event an application is not going to be made, we will dutifully contact the court so relevant arrangements can be made for other orders.
Yes, but we wouldn't want a situation where a person starts to prepare Well, I guess if your application is not filed, well, then it would not matter. Very well. So let me give you 29. In that case, if it is filed, then the other side would have until the 12th of November. But due to my diary, my difficulty is my diary in any event. So the dates, if that application does go forward, the dates for hearing will have to remain the 24th and the 25th.
Much obliged to you, Your Honor.
Very well, thank you very much for your patience. We will reconvene on the 24th. So we have hearing dates 24th, 25th, 26th, 30th, and the 1st.
Your Honor, if I may, please, briefly.
Just a minute, Ms. Robertson. I think I made a mistake with a date. Not the 26th, it's the 30th and the 1st. Yes, Mr. Robertson.
Your Honor, while the court has not addressed it specifically, just by the court's actions today, it appears that the court intends to hear these matters together.
Yes, that's a good point, yes.
Your Honor, we believe that the petitions are sufficiently different that the court may wish to consider hearing them separately. There is a very slight overlap in the issues raised between the two petitions, but for the most part, petition 99 goes into substantial detail, would require a substantial amount of evidence, and the court may find it more convenient to deal with that separately than petition 88.
Well, Mr. Robertson, I'm glad you brought that up. I did have that in my notes. But the issue is when you look at the prayers for relief, they're almost identical.
While that may be true, Your Honor.
Taking two different routes, but you're hoping to arrive at the same destination. And when one reads the prayers for relief, they are almost exactly the same.
That
there are some additions in 99, but a comparison indicates that the end result is exactly the same.
While that may be true, Your Honor, because
on two different processes separately. Yes, I'm hearing you.
While that may be true, Your Honor, because of the different nature of the two petitions, the course of trial is likely to proceed very differently in relation to 99 than it is with 88. And even though both petitions seek the same relief, to try them both together, just because the method of proving is so different in the two cases, it could lead to some confusion, Your Honor.
Confusion on whose part?
Your Honor.
Just a minute, Mr. Ford. Yes, Mr.
Yeah.
Yes,
Your Honor,
Mr. Confusion on whose part?
Your Honor, there's several counsel involved in these matters. And some of the orders, for instance, that might be sought along the way in 99 with respect to evidence, with respect to production of documents, would not necessarily apply to 88. And we don't want to create a situation, Your Honor, where people try to use procedures and applications that were relevant only to 88, only to 99, to bog down 88 or vice versa.
No, Mr. Robertson, be assured. Let me put it this way. I pray God that I will not be confused, so that when I make the orders, they will apply to the relevant petition. But to my mind, it makes no sense where we have petitions that are asking for almost exactly the same reliefs, that they be heard separately. I do appreciate, and I will hear Mr. Ford, I do appreciate that Mr. Ford said he will not be calling witnesses.
May
Very well, Your Honor.
May please, Your Honor.
Yeah.
Your Honor.
Yes, Mr. Ford.
Oh, thank you, Your Honor. Your Honor, in relation to the issue of hearing the matters together, or apparently consolidating them.
Well, I think because, if I might say so, Mr. Ford, I wouldn't want to use the word consolidation.
Okay, Your Honor, okay, I appreciate it, Your Honor.
They're being
Your Honor,
heard
but in terms,
two different things.
Your Honor, could I continue?
Yes, go ahead. I'm hearing you.
Sorry, Your Honor. No, Your Honor, I was saying that in relation to the two petitions and the hearing, I would ask Your Honor not to come to a settled decision on that as yet. Your Honor, the reason being, Your Honor, that in relation to the petition 88, the one filed by myself and the lawyers in this petition, it raises really and truly one substantial legal issue. That is whether the Section 22 is unconstitutional, and that is the sole issue, and all the other reliefs filed, Your Honor, or requested, are simply consequential in relation to that. So Your Honor, in my view, Your Honor, I believe that that petition could be heard and determined separately and independently from all the evidential issues which seem to be required for the second petition, Your Honor. So I just ask Your Honor to not come to a settled position as yet. We are still at the preliminary stage in terms of objections being made, but I'll ask Your Honor to consider that course, Your Honor.
Duly noted, Mr. Ford. I said duly noted.
Well, thank you, Your Honor.
Very well. Thank you very much, everyone. And just a minute, please. We will see you on the next date allotted by the court for a hearing, which should be November the 24th. Thank you very much.
Thank you very much, Your Honor.
Bye, Your Honor.
Nothing else stands adjourned.
Thank you.
Back to take leave.